Hi and welcome back to Property Insight. My name's Mark Ashworth.
I'm Neil Harding.
And on today's video we're going to be talking all things about the Renters Reform Bill. So I don't think we've spoken about the Renters Reform Bill before, so why don't we just have a quick chat about what it actually is and what it's about and who it's intended for.
We know that it was introduced really to look at a number of problems in the rental market and the experience really of tenants that struggle with certain aspects of renting. So one of the problems that a lot of tenants experience is that under a Section 21 notice, a landlord currently has the right to evict a tenant without having to give any reason whatsoever that they have to leave the property and vacate. Which I have to say, from my own personal point of view, I've always felt is a bit harsh, right, on tenants, because literally you want to live in your home. You might want to live in a home for years, and then one day on the doormat, a Section 21 arrives, and you have to leave, and you just think to yourself, well, you know, my children are at school. I live here. I've lived here for years, and now I can't anymore, and there's nothing you can do about it. It doesn't seem very fair to me. So that was a big part of it, and speaking as a landlord, I actually have no objections to Section 21 being abolished, and this was a big part of why Renters Reform Bill was introduced, to look at that. And then another big part of it was around the notice period that a tenant needs to give to vacate from their side. So there are fixed term periods in an AST, assured short hold tenancy agreement, typically, and often they're 6 months minimum, or 12 months is quite common as well. And in that period of time, under current legislation and current AST tenancy agreements, a tenant would not be able to give notice to leave before that fixed term period has expired. So if they give notice after 2 months because they want to leave, and the 6 month period clearly hadn't expired yet, they'd have to pay rent for the full 6 months. They'd be contractually obliged to do so. You could obviously come to an arrangement otherwise, but that's how the contract stood. And again, you know, not necessarily great for a tenant whose situation might change. So the proposal under the Renters Reform Bill on that one is that actually there's not really going to be any such thing as a fixed term period, and a tenant could give notice on day one if they wanted to and leave a month later.
I mean, I think on that point, in reality, I don't really think that's going to happen. I don't really think that's going to be too much of an issue. I think if people have gone through quite a lot of effort to go through referencing and finding a property, they've paid a deposit and they've done all these other things, I think really there has to be something fundamentally wrong with either the tenancy, the property, or the landlord in order for tenants to simply move on. I guess there might be the odd situation where somebody that wants to rent or wants to have a property on a very short-term basis may well jump through all those hoops in order to have the property for a month before, I don't know, they're waiting for another property to come up, or whether they bought a property and they need something just to bridge that gap. There is a slim chance that could happen, but they're going to need to be financially ready to be able to enter into that agreement. Probably one of the reasons why you need to make sure that you're taking a proper deposit, etc. But just on the other fact about the Section 21 being served to tenants, I think for many years, being in the industry for 10 years and hearing a lot about what landlords are talking about, is that, number one, if you have a property and you have a good tenant and they're paying their rent on time and the relationship is good, there's absolutely no reason why that tenant should be asked to leave. And there usually is a very good reason for that Section 21 being served. It could be that the landlord simply wants to sell the property. They've got to a point in time where they want to just sell the property, and there's not really an awful lot you can do about that or control the timing on that. But more importantly and more worryingly is that Section 21s have been used historically for removing tenants where there is a problem, and it's largely down to non-payment of rent, or not looking after the property, or generally being difficult, or perhaps never paying the rent on time is another one, or perhaps causing a bit of a nuisance to neighbours, or antisocial behaviour. And so because there is no reason to serve the Section 21, or there doesn't have to be a reason given, it's often in the way that the courts see it and the way that the landlords see it in the courts is that it's the most simple form of getting back your property. And so we'll move on now to what's in that renters reform bill, is that they're now saying that they can't abolish Section 21 notices until the court system is satisfactory in the sense that it's going to treat these issues with the importance that they deserve. So therefore, you can serve a Section 8 notice, which is for all those things I just mentioned, non-payment of rent, antisocial behaviour, etc. However, the court process isn't very straightforward or easy to use under a Section 8 notice, because it tends to be that those grounds are discretionary, i.e. it's down to the discretion of the judge to decide whether or not that tenant or that landlord gets possession of the property, or whether the tenant can move out, which quite frankly doesn't really make any sense. It seems that there's no point in having a legal contract if one part of the contract is being breached. What are you supposed to do in order to resolve the situation? Well, at the moment, serve a Section 21. So the problem is all the statistics around the reason why they want to abolish Section 21 is because it's being used, but it's actually being abused because there isn't any other way of actually satisfactorily resolving any problems. So that's the big issue.
Yeah, brilliantly summarised, I think. Yeah, completely agree. I've actually issued Section 21 before, and so I will be part of the statistic of no fault evictions. But I'm a portfolio landlord. I want tenants to be happy and live in my properties for a long, long time. I wouldn't have been looking to evict that tenant had they not been an issue.
So notice was served because of a problem.
Yeah, because of a problem.
Yeah.
And like you say, so there's a Section 8 notice which you can give, which subsections of Section 8, which give all sorts of reasons around things like antisocial behaviour, late and consistent delayed payment of rent, 2 months worth of arrears worth of rent. These are all sort of Section 8 notices. But actual fact, the amount of times you will hear landlords saying that they went to the courts, went through the systems, try and get possession of their property using a Section 8, and due to some sort of technicality somewhere, they had to start all over again and they didn't get possession. That is why often the Section 21 is used.
I think more importantly in the Section 8 notice is that most of those grounds are discretionary. And by discretion it means what sort of mood is the judge in?
Right.
It's not black and white. Whereas a Section 21 is black and white. I want the property back. You've got 2 months to give me it back, otherwise we go to court. Yeah. It's black and white. And so therefore there needs to be a black and white way of ending a tenancy when there's a problem.
At the end of October, the Renters Reform Bill received its second reading in Parliament. I think the first reading was about 10,000 years ago. They seem to take an eternity to do the second reading, and I think for quite a while people were wondering if it was ever going to happen. That has happened now, which adds a bit more certainty to the fact that, or the idea at least, that it will actually become law one day. So what was interesting is that at the second reading there are a couple of key points raised which would likely change the shape of the Renters Reform Bill, which I think you touched on one of them, Mark, which is that the removal of Section 21 as being an option for a landlord to get possession of their property has been effectively put the brakes on that until the court system have come up with a better way to deal with the scenario that you were just describing, Mark, so that landlords are actually able to get their property back using other channels or other section notices or other means, whatever that looks like. I'm sure it's still to be determined, but it needs to be less problematic than the current Section 8 route, which, let's face it, if you get your property back inside 6 months, you're lucky, and that's quite unusual. It's more like 9 months or even a year or more. And of course, in that period of time, if things haven't gone very well, you're probably not receiving any rent, and it's very problematic. So actually, if anything, you could describe it as a win for landlords, but actually I think it's a win for common sense, because it's got to be an equal balance given to both tenant and landlord. It's an equation. It's got to work for both sides. It's not just about giving all the rights and powers to either the tenant or the landlord, because that's neither's going to work either. So I think this is common sense.
And it's not a case of whether or not we're standing up for landlords or for tenants. That's not really the argument, in my view. It's the fact that the system's broken. And when a tenancy between a landlord and a tenant is broken, There doesn't seem to be anything that can actually solve the problem. It's unfair for the landlord if there's a tenant that simply won't move out and continues to not pay rent. In any other scenario, in any other contract, that just wouldn't be allowed to happen. And obviously the intention when someone signs an agreement is that they agree to pay the rent at a certain time. And that's, that's what it is. It's an agreement bound by law. But it doesn't seem that the law wants to be able to provide the best solution in a timely manner as well. And we're not talking about, we don't obviously necessarily want it done the next day, but when you consider things like this, properties are expensive and rent's expensive and it's a home and all these things are really important. And I think it's key to make sure that the private rental sector is run in an efficient way. And currently, with that end of it, it's just not very efficient at all.
Another change that was received at the second reading was around particularly the student tenant population. Mm-hmm. So there were particular concerns for student tenancies and landlords that's probably specialise in student-let property around that idea that a tenant could give notice almost immediately and vacate, or that the Section 21 is going to be abolished. What does all of that mean for a tenant type that, let's say, traditionally has sort of recycled annually every September in line with the academic year? So, how does that work if you're expecting a 12-month fixed term tenancy period to recycle every 12 months and probably new tenants moving in September, tenants moving out, new tenants moving in? That's very difficult to get your head around if, Section 21's gone, you can't get your property back. What if it's one student with 4 other people in an HMO and one person decides to stay, and it's very, very difficult. So actually what they've said is they've recognised that issue and it needs more clarity and it needs more thinking through, which I think is a really good thing, especially for all the tenants and landlords out there that specialise in student lets. And there's going to be a specific possession notice order that will be made available. I think it's yet to be defined, so there'll be more detail that will come out on exactly how that works in the future. But I think that's a really good thing and will add clarity. So at the moment, I think we're in a let's watch this space. Who knows? There'll be a 3rd, 4th, 5th, 7th reading. I don't think there will be. I think that's it now, and I think they're going to hopefully pass this into law at some point in the forthcoming year or 2025. I mean, perhaps one closing comment is there's always the possibility, right, that the government changes its mind.
Does nothing.
Does nothing. There's always a possibility that there's a general election in 2024 and there's a different party that comes to power and they decide to completely change it, scrap it, or go with the very first version that was at the first reading. Who knows? So it's a bit of an update really, but that's where we're currently at. So as always, we hope that has been insightful and that you enjoyed the video. Look forward to seeing you next time.